Yes, Mr. Owen.
My Lords, I'm grateful for the chance to do a bit of research and to my learned juniors for the assistance that they've given. We've come up with what I hope is an answer, our suggested answer on what I think, from the court to be what are the procedural options open to a court to avoid potentially an unfair or unjust outcome in relation to an award of damages on the assumption that reputational damages are available in relation to this tort. The issue will primarily arise where there is a MOPI claim in relation to the publication of information about an ongoing or live criminal investigation. If the criminal investigation has been closed and the person is entitled thus to be considered innocent, there's not going to be a charge or a trial, the issue of damages being awarded for a reputation one doesn't deserve won't arise. And the Sir Cliff Richard case fell into that category. He was never arrested. It was a search of his house as part of an early investigation. So if the investigation is ongoing, then there are, we would suggest, these options for a claimant or the parties or the court to consider. Option A claimant can seek damages for the disclosure of the private information, but not put in issue or contest the truth or falsity of the underlying information, and not include in the damages claim a claim for reputational damages. And that's this case. The second option, in the context of a live investigation, is a claimant could seek damages for reputational harm, but in that scenario, the claim could be stayed until the investigation is concluded. And CPR Rule 3.1, brackets 2, brackets F, CPR 3.1, brackets 2, brackets F, provides that the court may, quote, stay the whole or part of any proceedings or judgment, either generally or until a specified date or event. And as the courts may be aware, it will often be the case in a context of a long-running fraud inquiry. There'll be a criminal investigation, but there'll also be potentially liquidators who are involved and who are bringing civil fraud proceedings against persons who are also simultaneously the subject of a criminal investigation. And there is often then a question of whether the liquidator's claim in fraud should be adjourned pending a charging decision in a criminal trial. And so the courts are well used to exercising the stay power in that scenario. That power does not, in fact, derive from the CPR, but from the senior court's inherent jurisdiction as recognised by Section 49.3 of the Senior Courts Act of 1981. And so, in the context of a stay being under consideration or having been granted, if the position results in the person not being charged, the investigation closes, then it's the Cliff Richard case. The case continues. If, however, the person is subsequently charged, then obviously the claimant will inevitably be publicly named and will suffer the same consequences as he would have suffered or would have occurred already as a result of the disclosure of the private information. Now, in that scenario, if the person is subsequently acquitted, then they could also claim for the reputational harm they suffered when the private information was improperly published. And so the scenario is you've stayed the claim, a charge has been laid, but then the person is acquitted. The case then comes on, and on the basis there was a claim for reputational damages, we say there's no objection in principle for that being part of the damages.
I'm not quite sure how that would work, because
there can't be a complaint that a public charge is laid against the person. And isn't it that would have the immediate impact upon their reputation?
No, what I'm suggesting is that this is a person who has pursued a claim for reputational damages from the outset. The claim is then stayed as a result of the person being charged. They're then acquitted. There is then no problem about that aspect of the case, the reputational harm case, from the private information being published.
But you're envisaging that there is a public charge levelled against them. There has to be in order for there to be a trial.
Yes.
And that public charge shows they are the subject of a charge.
Yes.
And has the impact on their reputation.
My Lord, yes, it would be for the limited period before they were charged. So in other words, the distress and harm to reputation that they suffered up to the point of charge.
Right.
From the date when the private information was wrongly published to the date of charge. So there is no, what I'm saying is there is no conceptual difficulty in my submission about awarding damages on a false basis in that scenario for that limited period.
But why does it matter whether they're acquitted or convicted on that basis?
Well,
you now seem to be envisaging that.
Well, I'm going to come on to if they're convicted next. So I've said if they're acquitted, no problem about reputational harm for the limited period up to the date of charge. If they are convicted, they would still have suffered distress from the publication of private information about them being suspected of criminal activity at a time when that information should not have been published. But it could be said that they ought to, so it could be said they ought to have a remedy for that. But it may be thought that this would be to award damages for loss of reputation they didn't deserve. And so the court, in that situation, the stay having been lifted, the person has been convicted, the court then is simply having to consider, well, the award should be one which is not seen to be, and does not in fact award damages on a false basis and give you compensation for a loss of a reputation you don't deserve.
But in a sense, you did deserve it because there shouldn't have been in the period of trial. There shouldn't have been an impact upon it.
Yes. I'm suggesting it may be a nice point. It may be a difficult question. It may be the damages wouldn't be significant. But yes, as a matter of principle, as I said, you'd still have suffered the distress. You'd still have been the victim of a wrong in relation to the publication of the private information at a time when that shouldn't have happened. It's just that the damages are likely to be rather modest, perhaps. So that's the stay option. Another option is a court could order a split trial on liability and damages. The power to do that is under CPR 3.2 Roman 1, quote, the power to direct a separate trial of any issue. So that's an option. And then fourthly, the court, and this is, I think, the solution that Professor Phillipson and Robert Craig flag up, the creative escrow option. The court could order a party to pay a sum of money into court in respect of the damages, conditional upon the outcome of the criminal investigation. And that could be done in either a stay situation or a split trial situation. I think my Lord Stevens flagged up the question of provisional damages, but the power to award provisional damages is limited to personal injuries actions. Quote, limited to actions for damages for personal injuries in which there is proved or admitted to be a chance that at some definite or indefinite time in the future, the injured person will, as a result of the act or omission which gave rise to the cause of action, develop some serious disease or suffer some serious deterioration in his physical or mental condition. And so that's section 32, capital A, brackets 1, 32A1 of the Senior Courts Act 1981. And there's a similar power in the County Courts Act. So it means the court doesn't have a statutory power to make an award of provisional damages in a claim for misuse of private information. But the court does have a power under CPR 3.1(3) to make any order that it makes conditional upon a party paying a sum of money into court. And it provides, quote, when the court makes an order, it may, subparagraph A, make it subject to conditions, including a condition to pay a sum of money into court. And so it appears a court could order a defendant to pay a sum of money into court pending the outcome of a criminal investigation into the claimant, whereupon the money would be paid to the claimant if the investigation terminates, or would be paid to the defendant if the investigation results in the defendant being charged and convicted. One would then, the point that my Lord Sales put to me, you still have to negotiate or adjudicate, rather, about what the right measure of damages should be if the defendant has been convicted. But the power procedurally under the those provisions does seem, we would respectfully submit, flexible enough to factor in protections against a defendant being ordered to pay damages inappropriate or on a false basis.
So on this scenario, are you envisaging that the quantum part of the proceedings isn't actually brought to a close?
Yes.
That there's some sort of interim payment into court, but still leaving things open.
Yes.
Or debate later on as to what should be taken
as to what is the appropriate element to be awarded, if any.
Right.
I'm putting this forward simply because the court have asked for assistance on it. I mean, obviously, it may be thought more appropriate to adjudicate or to be set out guidelines in a case in which this type of problem has arisen. As I say, this case in my submission doesn't create any of the problems, the reasons I've explained. But it seems to us that there is flexibility procedurally to avoid a situation which could be seen to be unfair or unjust. And again, I can't remember whether I gave you the specific notes. In our case, the learned trial judge, Mr. Justice Nicklin, faced up to the issue of the proper basis to award damages and the concerns about awarding them on a wrong basis in his judgment at paragraphs 149 to 152, electronic bundle 377 to 379. And in my submission, his analysis there and the conclusion that he reaches as to why those difficulties don't arise on the facts of this case are entirely correct.
The analysis that you've undertaken,
yes,
relates to whether or not a person is convicted or is innocent.
Yeah.
But the defamatory meaning, or the meaning that affects reputation, ordinarily, well, certainly Lewis against Daily Telegraph, isn't that he was guilty.
No.
It's that it's the chase level 2 and 3.
Yes.
There are reasonable grounds to suspect the claimant is guilty.
Yes.
So the conviction or the acquittal may have very little to do with that.
Yes. You're being compensated for the damage or harm caused by the impact of chase level 2 and 3, albeit in a moppy claim.
Yeah. And in what circumstances, where there is a police investigation, would there not be reasonable grounds to suspect that the claimant is guilty?
I'm sorry.
In what circumstances, where there is a police investigation, will there not be reasonable grounds to suspect that the claimant is guilty?
Well, one operates absent some extraordinary evidence of malice.
Yes.
That's right. That would be the implication of the existence of the investigation. And if it's a search warrant case, like Cliff Richard, the court will have granted a search warrant on the basis of being satisfied of reasonable grounds to suspect. And so the public's perception, and therefore the potential for the infringement or causing of the harm protected by Article 8 will inevitably flow from that. Can I just...
This has been a problem, but really from the outset of this tort. Campbell itself was a case where the claimant had maintained that she did not take drugs.
Yes.
And the publication of the material implying that she was being treated at an addiction clinic. Obviously, well, it meant that insofar as her reputation was damaged by that, it was an undeserved reputation.
Yes. And those aspects, I think there were 5 aspects that were identified, and it was only 4 and 5 which the majority found she could be compensated for, and that was because it was an invasion, effectively, of privacy over a matter to do with her health.
Yeah.
It may be justified to ensure that, effectively, it was saying she's fair game because she had gone around saying, I don't take drugs, so she couldn't complain about that aspect of the intrusion. But the photograph of her and the fact of her attending Narcotics Anonymous was an interference.
Yes.
An unjustified interference.
So the approach to damages there was what exactly?
I'd need to go back.
I'm sorry, I'm rather asking you on the hoof.
I'm sure I'll be given the references to the paragraph.
The case begins at 945.
You've got the page. Sorry? Yes, I'm being told, obviously Mr. White was in the case, that the damages issue was not addressed in the Lords.
Ah.
So it may be we'd have to go and look at the original judgment to see how that was dealt with in detail.
Yes. Right, okay.
It may be... Yes, thank you. Page 947. One sees where there's the summary of the proceedings below. Do you see on 947 at E the modest damages that were awarded? Mr. Justice Morland gave judgment and awarded her £3,500 in damages. Yeah. Yes, and at paragraph 10 of Lord Nichols' speech, page 952 in the bundle, Lord Nichols, in giving the narrative, said, in the proceedings, Miss Campbell claimed damages for breach of confidence and compensation under the Data Protection Act. He made her a modest award of £2,500 plus £1,000 aggravated damages in respect of both claims. I think that's all there is in the judgment in the House of Lords. But again,
yes.
In privacy claims, and it was certainly, as you know, the case in this claim, the prime remedy that was being sought was the injunction. effectively to preserve the privacy of the information.
Yes. Yes. So one can infer from the modesty of the award that she wasn't being compensated for any loss of reputation,
No.
Consequent on being revealed to be a drug addict.
No, that harm was there and justifiably so on the basis of the findings. There may be some assistance. Perhaps I should just show you this. It's Mr. Justice Nicklin's judgment at 149, Roman 2. It's electronic bundle 377. Mr. Justice Nicklin here in the paragraph he's saying, in my judgment, there is some force in Mr. Miller, he was counsel for Bloomberg, in his submissions, and care must be taken when assessing damages in misuse of private information cases. And he says there's no dispute reputation is an aspect of the Article 8 right. Difficulty arises because English law accommodates the right in different ways. Sorts of defamation and misuse of private information, with data protection being the principal private law remedies. These causes of actions can't be neatly divided into their own compartments. They overlap, and the point that my Lord Reed made. And then this, damages awarded in defamation claims serve three purposes: compensation for the damage to reputation, B, vindication of the falsity of the defamatory allegation, and C, compensation for the distress, hurt, and humiliation which the defamatory publication has caused, the so-called solatium. And at 150, and perhaps I should show 149 Roman 4 on the next page. He says it's a fundamental principle in the law of defamation, damages and vindication of reputation should not be awarded on a false basis, i.e. where the defamatory allegation can be proved to be substantially or partially true. This principle is important in balancing the Article 8 and Article 10 rights. Looked at through this prism, the imposition of an award of damages for damage to reputation is an interference with the Article 10 right, which can't be said to be necessary to protect the Article 8 rights of another if the defamatory allegation is true. And then he sets out the principles which he then derives from that background, that damages awards in misuse of private information can't ordinarily include elements for compensation for damage to reputation and or vindication of reputation, elements A and B from John. To award damages for these elements while at the same time holding that the truth or falsity of the information is irrelevant is wrong in principle. Insofar as any damages awards were to be increased to reflect these aspects, the additional element is non-justifiable interference. If he wishes to seek an award of damages that reflects elements A and B, then a defendant would have to be permitted to defend as true any underlying defamatory allegation that fall within the claim for MOPI. The element of solatium is an element common to damages awards in both defamation and MOPI. In support of his/her claim for damages and misuse of information claim, it is at least arguable a claimant is entitled to rely upon the elements of distress and upset caused by his/her belief that the allegations are false and have damaged his/her reputation. The basis for this is that, true or false, it was a misuse of private information for the relevant information to have been published. And then he sets out, perhaps to my Lord Jones's question, the tort of MOPI focuses on the protection of human autonomy and dignity, the right to control the dissemination of information about one's private life, and the right to the esteem and respect of other people. Of course, esteem is often bound up with aspects of reputation. It might be better to use the phrase damage to the standing of the claimant rather than reputation when referring to this element of privacy damages. But whatever it is called, in a MOPI claim, a person can't be awarded any element of compensation for harm to vindication of reputation caused by the publication of defamatory statements if the defendant is not given the opportunity to defend the statements as true. That would be to award at least some element of damages on a false basis and be contrary to the principles I've set out. And then he goes on to say that because of the concession, it's not a relevant issue. In my judgment, the consequence of that is, whilst he can legitimately rely upon the distress and embarrassment he's felt as a result of the publication of the information, he can't be awarded any element of purely reputational damages. And
I'm not myself completely sure how that fits with what the judge says at 149(3), that the truth or falsity of the information that forms the basis of a complaint of misuse of private information is generally irrelevant.
In the sense, well, what he's saying there is that the tort exists to protect the privacy of the information, true or false. Plainly, if you're pursuing in a MOPI claim both damages for the publication of the private information on the basis that it should never have been published, it should have remained private, but you are also seeking damages for the reputational harm that was caused by its publication.
But why can't you say it should never have been published, it was, and that's caused me reputational harm?
Well, you can, as long as the defendant has a chance to defend it on the basis, well, no, it is true.
But why does that last step come in?
Because in a case, not like the example that my Lord Reed gave of the true information about a person's medical records, the truth of the allegation is truly irrelevant to the reputational harm that is caused. The fact is, it is true.
I see. Thank you.
I see. I've just been reading the speech of Lord Hope in Campbell, and who was one of the majority judges, and his approach was to distinguish between the information that she was a drug addict, which was something she had previously denied.
Yes.
And therefore, the view was taken that she couldn't have a remedy. Effectively, the press were entitled to disclose the fact that she had lied about this.
Yes.
And on the other hand, the information about her treatment and the intrusion in form of photography of her attending the clinic,
yes,
those were elements for which damages were recoverable.
Yes.
In his view.
Yes. Can I just come back to the point that my Lord Sales was putting to me? Because I don't think I answered your question. I think what my Lord was putting to me is that 149 Roman 3, first sentence, is in a sense wrong so far as it uses the word generally, because in fact truth or falsity is always irrelevant in a MOPI claim, because you're complaining about information which is private.
Right.
Which should never be disclosed. And so you will get damages if you succeed in showing that it was private and should never have been published. There was no justification for it. You should get damages.
In fact, I wasn't seeking to focus on the word generally. I was more concerned with just the logic of how this fits together, that you can complain of breach of privacy even though the facts are true.
Yes.
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 And so the wrong is something has been published about you, which
yes,
has an effect upon
yes,
you, your standing.
Yes.
I would suggest that one might say your reputation as well.
Yes.
Which should never have happened.
Yes.
Why can't you? Why doesn't the remedy match up with the wrong? And why can't you claim loss damages for the loss that you have suffered by reason of that wrong, which is that you've been exposed, your standing has been diminished, your reputation has been affected?
Well, my Lord, I'm saying you can be. You can be awarded damages on that basis. It's just that in the example that I gave earlier about a person who is subsequently convicted, if you have been awarded damages on the basis you've claimed damages for reputational harm, yes, you're entitled to it for that period when it should never have been published. It just may be, obviously, a much lower award if, in fact, the information is true. Because you will have known.
In fact, when we had the exchange, what I was struggling to understand wasn't so much that part of your submission as you saying, but the defendant should be allowed to prove the truth of
yes,
the underlying facts, and that would somehow constitute a defence to part of the claim.
Well,
Can you help us with that?
I've accepted the principle that Mr. Justice Nicklin has set out because it comes from his analysis that to award damages, it's what he says in Roman 2 under paragraph 150, to award damages for these elements while at the same time holding that the truth or falsity of the information is wrong in principle. Now, I've accepted that. I suppose it's a question of the appearance of unfairness of if you are choosing in the way you're advancing your misuse of private information to make the truth of the information an issue in the case, which you don't have to do, but if you choose to do it, that it would be unfair in principle to prevent the defendant from saying, well, since you put that in issue, I'm going to show you that it is true. So that's, as I understand it, the thinking behind Mr. Justice Nicklin's analysis.
Yes, thank you.
Well, it strikes me as a rather muddled analysis. In Roman 3, at the top of the page, he is quite rightly saying that truth may be an issue if it's raised on the issue of a public interest offence or Article 10.
Yes.
So clearly, if the information is true, that may go to the extent of a public interest in publishing it. But Roman 4 takes us to a principle in the law of defamation. What's that got to do with it?
Well, if you go back to Roman 2, he's here looking at the basis on which awards of damages are made in defamation claims. He says it serves 3 purposes. Compensation for the damage to reputation, and then B is vindication of the falsity of the defamatory allegation. And so, so there are 2 types of reputational compensation, if you like. And what I think he's saying is that it would certainly be wrong if you are pursuing a MOPI claim and you are seeking damages for vindication of the falsity of the defamatory allegation in a privacy claim. It would be wrong for a court to award damages under that head without a defendant being able to limit his liability in damages. It wouldn't eliminate liability altogether, but it would limit it to ensure that the damages are awarded on a basis which is fair to both sides.
Yeah. Well, the way you're putting it is a more attractive way of putting it than the way the judge puts it. He's simply trying to avoid inconsistency with the law of defamation.
Yes.
And in principle, there's no reason why there should be consistency, because they're different wrongs.
Well, it's no part of my case to, as you've perhaps picked up, I'm all in favour of not treating the MOPI tort as if it's the defamation claim and importing the principles from defamation law into what I've said all along is a very simple and straightforward legal framework, and which does not depend on the truth or falsity of the information. It's protecting a completely different right.
Yeah.
In the Campbell case, if you use the but-for test, but for the fact that this matter was published, she would have maintained her reputation because no one would have known that it was a lie.
Yes.
That if you use that as the test, she would be entitled to damages for the effect on her reputation.
Yes.
And
that's right.
So it's difficult to at present to see why it's wrong that damages, that you can't get damages for something that's actually true.
Yeah. I'm sorry, my lord.
That you can't get damages for something that is actually true, insofar as it affects reputation.
Yes, and you have chosen, in the way you've advanced your case, to try and get a vindication of the falsity of the defamatory allegation. That would be, I see, offensive. Lords, unless I can assist further, those are my submissions.
Thank you very much indeed, Mr. Owen. Mr. White.
Lord, rather than start at the beginning of Mr. Owen's submissions is perhaps traditional for a reply. I'm going to dive back into the debate we've been having because it's very important and it's obviously concerning the court. My Lord Reed prompted the discussion by an observation you made immediately before lunch by reference to Lewis and the Daily Telegraph. Yeah. You said, my note won't be completely accurate, but I hope it's more or less accurate, that if it's reputationally damaging to say that someone is under investigation, they should be able to recover damages for that, true or false. Now, my Lord, that raises a very important point about consistency with the law of defamation, which Mr. Owen didn't address head-on in his submissions, which was this question of the rationale for an existence of the conduct rule. The point about reputational damage as a result of publishing information to the effect that someone is under a criminal investigation is, as has been hammered out in the law of defamation over centuries, it is reputationally damaging only because it implies something about their conduct, namely that they have brought down, by their conduct, suspicion on themselves. And that is why in defamation you can defend it as true, not by saying there is an investigation or someone else suspects you, but by pointing to their conduct which has brought the suspicion down on themselves. And it may be my fault for not making that clear enough in my submissions, but it's a very important point when we're considering the appropriate structure of the law in relation to the disclosure of information about criminal investigations. Could I just show you a very neat summary of the law in that area in Mr. Justice Warby's judgment in Sikri? It's at page 1548, paragraph 148 of Sikri. I showed you the case of Shah yesterday, an older Court of Appeal decision, but this is a slightly fuller explanation, and it also explains why Mr. Justice Warby saw the award of damages for injury to reputation in Cliff Richard as unobjectionable, because there was in that case no defence to a libel claim based on the claimant's conduct. It wasn't said by the BBC that he'd brought the investigation down on himself. So in 148, after setting out the passage we saw in Richard before lunch, Mr. Justice Warby says the limited nature of the defence submission recorded in this passage is notable. That's that there was an investigation afoot. It's well established in defamation law, one, the ordinary reader will normally understand a statement that a person has been arrested for a crime to mean there are reasonable grounds for suspecting him of that crime. That's the defamatory sting in saying someone's been investigated. Accordingly, such a statement can only be defended as true by proving there were objectively reasonable grounds for suspicion. Three, the grounds to be relied on must focus on some conduct of the claimant by which he brought suspicion on himself. And four, the proof of mere fact of suspicion or investigation cannot be an answer to a claim. And then he cites a number of authorities consistent with the law that I showed you yesterday. But my Lord, once one gets that into sharp focus and realizes that if Bloomberg had been sued in defamation for publishing the fact of the investigation, it could have defended as true the defamatory sting that there were reasonable grounds to suspect, because it is, and it doesn't matter for present purposes whether it's admitted to be true or not, it's not denied, it's not said to be false, that he provided misleading information to the board of the company. So we would have had, in a defamation claim based on harm to reputation, a defence of truth. And that is why it is particularly inappropriate to outflank that long-established aspect of the law of defamation by saying I can base a reasonable expectation of privacy on the harm to my reputation of publishing the fact that I'm under criminal investigation.
At the moment, I'm not sure that follows. The difference between a claim in defamation and a claim in MPI is the disclosure of private information.
Lord, that I agree.
That's the sting, if you like, of the tort.
But the rationale for protecting it is the protection from unfair harm to reputation.
Well,
it's not unfair harm to reputation.
Well, my Lord, that's the expression used in the police practice materials. That's said to be, we point that out in our case, that is said to be the rationale for the police not naming suspects.
That may be so, but it's certain. I mean, the tort's been created in order to meet the requirements of Article 8, which weren't previously met by the common law. And Article 8 is essentially concerned to protect the personality of individuals, self-respect, the personal integrity, a sense of selfhood, however you want to put it. I mean, that's the rationale for protecting their private lives.
Lord, I accept that, but this development of the law of misuse of private information to protect against reputational harm caused by publication of information about a criminal investigation has been built, and one sees it in Richard, and one sees it again in the judgments below in the present case, has been built on the risk of damage to reputation, which is already catered for, and this is my bedrock submission, it's already catered for in a way which balances the respective rights in play in the tort of defamation. Defamation also protects Article 8 rights, and in particular it protects that part of Article 8, which includes the right to reputation. Yeah. But what is the concern, and one sees this very strongly articulated in Mr. Justice Warby's judgment in Sikri, is that the centuries-old balancing in the common law of the rights to free speech and protection of reputation in the tort of defamation shouldn't be sidestepped by an emergent tort. There isn't a lacunae. It's already dealt with in that established mature tort in a way which balances the rights in play. And the danger which is to be guarded against, and my Lord, I do strongly pray and aid the observations in Cuja and in Rhodes about developing other torts in a way that supplements or extends defamation. Those are legitimate concerns when looking at this emergent tort. What shouldn't be allowed in this context is to have a different outcome on the protection of reputation as resulting from publication of information about a criminal investigation than would result in defamation. And Lord, it goes further, and further points which Mr. Owen didn't meet, to defend reputation through the tort of misuse of private information outside the 1-year limitation period that Parliament has put in place where someone seeks to vindicate their reputation would be a serious outflanking.
Right, but, well, I mean, Lord Sumption says, forgive me, I forget which of the cases it was, whether it was Cuja,
yes.
That
it would be incoherent, was his expression.
Well, no, I had in mind where he says that there are, the misuse of private information is now an alternative means to secure remedy in relation to damage to reputation. Well, if that's so, I mean, one often has, as indeed my Lord had pointed out, different causes of action. Sometimes limitation affects one and not another, in which case it's perfectly acceptable to sue on the one that remains available to you.
Well, Lord Sumption said two things in Cuja, but he specifically held in relation to the risk of inconsistency between defamation and misuse of private information, that it would be incoherent for the law, that's the expression he uses, to allow a remedy in misuse of private information where application of defamation to the same fact situation would refuse a remedy. Thank you very much. 1431 at the top, you need to pick it up at the beginning of subparagraph 3 of paragraph 34. In fact, it has both notions in, my lord.
I'm so sorry, which page?
Page 1430. The impact on PNM's family life is indirect and incidental, the same way as the impact on the claimant's family life was in Reyes and M's family life in Guardian. Neither PNM nor his family participated in any capacity at the trial. Nothing was said at the trial related to his family. But it's also indirect and incidental in a different and perhaps more fundamental sense. PNM seeking to restrain reporting of the proceedings in order to protect his reputation. Parties entitled to invoke the right of privacy to protect reputation. Well, that's the line that you recalled. But as I've explained, there's no reasonable expectation of privacy in relation to proceedings in open court. The only claim available to PNM is based on the adverse impact on his family life, which will follow indirectly from the damage to his reputation. It's clear that in an action for defamation, no injunction would issue to prevent the publication of a fair and accurate report of what was said about PNM in the proceedings. It would be both privileged and justified. In the context of the publication of proceedings in open court, it would be incoherent for the law to refuse an injunction to prevent damage to PNM's reputation directly, while granting it to prevent the collateral impact on his family life in precisely the same circumstances. So that is a specific reference to the need for coherence in relation to the protection of reputation by both of the torts. And my lord, it's that concern which underlies the point I referred you to in O and Rhodes, which I'm going to come back to in a minute. O and Rhodes being the case in this court that developed the Wilkinson and Downton tort. And there was much discussion about the parameters and whether it could be used for insulting or damaging speech of varying kinds. And Lord Neuberger said, at paragraph 111, that the tort must not be used to somehow supplement or extend the law of defamation.
Mm.
It's
clear, it's apparent from the European cases that we've looked at that they refer to the legal systems of other contracting states where there is a developed law of privacy.
Yes.
And from what they say, it appears that there is a distinction understood in those legal systems between the extent of the protection afforded by the law of privacy on the one hand and the law of defamation on the other. We haven't really bottomed that out, and it's not analysed in the Strasbourg case law if I respectfully say so, in the most lucid way. But it may well be that if one looks at a textbook on German law or French private law, we may be able to get a better grasp of how what this distinction amounts to. I mean, at first sight, it looks rather sophistical to say that you can't recover for or to draw a distinction between reputation and standing, for example. It's not at all clear how one draws that distinction. But it may be that the Strasbourg law itself is not a very fully developed system. But obviously, a legal system like German law or French law is going to be much more developed than that, and may have developed a clearer understanding of how you can draw a distinction.
Well, my lord, I see that. Of course, the passage, my lord, I think has particularly in mind is at page 1669 in Caraco.
Yes. The
paragraphs 22 and 23 that I drew attention to yesterday,
yep.
Which we say are important.
Yeah.
Just before we move away from Cuja,
yes.
I was reminding myself, it's paragraph 21 of Cuja was the passage in Lord Sumption's judgment that I was recalling. That's page 1421. And that's in the passage where he's actually calling attention to the differences between the privacy tort and defamation.
Yes, my lord. I'm sorry. That is a further reference to the.
So he's expressly if you like, in that passage, emphasising that they're not coherent with each other because the privacy tort goes wider and protects reputation even when the matters published are true.
Yeah.
So I think one needs to be a little bit careful about your reliance on later passages where he's talking about coherence. I just wonder whether it might be said in the later passages what he's really focusing on is coherence in a situation where material has been referred to him in open court, which was the circumstances of that case, and whether it would be sensible in those circumstances where anyone could have been in court, listened to the information being given, to say that still there's some element of reputation that additionally needs to be protected.
Lord, it is difficult, but I do fasten on to the passage that I read as suggesting that in exactly the same fact situation, if there was a clear and established answer from the tort of defamation, it would be incoherent to give a different answer. As my Lord Reed's commented several times, Article 8 can provide, the misuse of private information tort can provide protection in circumstances where defamation can't. But the situation which confronts the court in the present case isn't one of them. The law of defamation could have protected ZXC, but it wouldn't do because in this case, his own conduct brought down the suspicion on his head. And just because there's a defence available in the tort which was naturally applicable to the protection of reputation in a given situation doesn't mean you have to develop a different tort to achieve a different outcome. And indeed, that's the very thing which both Lord Sumption in Cuja and Lord Neuberger in O and Rhodes are concerned about. Now, my Lord, I'm sorry, just to go back to Karoko at paragraphs 22 to 3, I entirely take my Lord's point that I confess to finding this often when I read Strasbourg case law, that the language has a level of density and conceptual difficulty that I sometimes read and reread. But there does seem in our submission to be a clear distinction drawn in paragraph 23, a clear conceptual distinction between external evaluation, it's what other people think of you, and that's not protected by Article 8, and the internal integrity of the individual, which is a different matter. This is the passage I founded on yesterday for the threshold of severity, as explained later in Denisov in evidential terms. The notion appears to be that the external evaluation of others, that others make of oneself, is not the field of Article 8, but its impact may be so severe on one's internal integrity that it may bring Article 8 into play.
This is it's a majority judgment, that there's a very detailed dissenting judgment, a judgment that dissents in relation to paragraphs 22 and 23. I wonder, you may not know off the cuff, but I wondered if Karako has been followed in subsequent case law.
Well, I don't, and we'll look that up.
I think it's just a chamber.
Yes, it is.
Right? It is a chamber decision.
Yeah.
But, my Lord, I submit, as I did yesterday, that it's important to see that it was effectively adopted and applied by this court in Re Guardian, in distinguishing between the four men before the court in that case, as I explained yesterday, only one of all of whom were affected in terms of the evaluation of others of themselves, if they were de-anonymized, but only one of them was affected internally in terms of his relationships within his family and community. And so that distinction, we will certainly see if it has been articulated or explained in later cases, but it has, in those terms, been adopted into English law in Lord Rogers' speech in Guardian that I drew attention to yesterday. And then in Denisov, as I showed you yesterday, the degree of severity of impact on the internal is spelled out very clearly and I apologise for repeating the submission, in a way which is not surmounted in the present case.
Was that argued in the lower courts? Was there a contention that the serious consequences didn't meet the threshold?
My Lord, the focus on reputation really emerged as a result of the Court of Appeal's judgment and no smoke without fire. So there was there was reference to Yeo where the Caraco distinction was drawn.
But the serious consequences aren't confined to reputation. They're confined to all the consequences. If you apply the consequence-based approach, and so it applies to self-esteem, to one's own dignity, and so on. Yes. So I mean, it wasn't. I didn't perceive it to have been argued in the lower courts.
My Lord, the passage I had in mind, if you just forgive me for a moment, I didn't do the case at first instance, yes, but I relied heavily on Yeo in the Court of Appeal, where Yeo cites the Caraco distinction. But I recall that Mr. Miller's submissions based on Guardian and Yeo were recorded by the first instance judge. I don't know if Ms. Hamer can take me there quickly.
I'd understood you to be arguing that the degree of severity of the interference in this case doesn't meet a threshold. And all I wanted to know was whether that argument had been raised at an earlier stage.
Yes, well, I don't want to contradict my learned friend. Yes. My reading of paragraphs 114 and 116.1 do record. In 114, there's reference to the Yeo decision, and then 116.1.
This is page what?
I'm so sorry, my Lord. Page 363. A person, this is Mr. Miller, my predecessor at first instance, a person asserting that his or her Article 8 rights are engaged by the publication of the material that may damage his or her reputation must demonstrate the attack on his or her personal integrity and that it must attain a level of seriousness in a manner causing prejudice to personal enjoyment of the right to respect for private life, citing the Guardian passage, which itself adopts the Caraco threshold of seriousness. It's Guardian at 42.
Lord, just on this point, of course, I accept that that's was recorded, but at 144 Roman 3 on page 376, Mr. Justice Nicklin, in the context of an injunction that does serve a useful purpose, said, third, the claimant's evidence as to the impact of the publication, the information on him was not challenged at the trial. Yeah. And at 153, also, the evidence on damages was not challenged by the defendant.
Yeah.
Lord, it's because of that I took you to the evidence yesterday. Yeah. It wasn't challenged, but the submission about the level of seriousness is there in 1161.
Yes, thank you.
Lord, we submit that the distinction drawn in Caraco and adopted in Guardian is of assistance, and the Article 8 tort, misuse of private information tort, is not concerned with that external evaluation, the what others think of one. There may be compensation for the undermining of personal integrity. That's put as the counterpoint to the external evaluation of others. But, my Lord, may I make this submission? The last hour or so of argument have they not, shown the very real practical and procedural difficulties that might arise if the emerging misuse of private information tort could award damages for injury to reputation. All of those difficulties, as Mr. Justice Sikri Mr. Justice Warby observed in Sikri, are avoided if the natural, mature tort protecting against injury to reputation is the one used, and used within the limitation period Parliament's prescribed.
I mentioned just one further thought, and it is only that at this stage. I wonder whether there's a degree of scope for reconciliation of the tort of defamation with its own particular defences and so on, and the tort of misuse of private information at the level of damages. So I think we were shown a passage where Lord Bingham identified one of the points of the remedy which is given in a defamation case was to show vindication of the rights of reputation. Now, clearly, in a sense, you're not doing that when you're suing for misuse of private information. You're not going to the underlying information and trying to vindicate your reputation in the light of that. You're just saying, this is private information which should never have been used and it's affected me. And I wondered whether one might say that, consequently, one would expect the level of damages to be less in a misuse of private information case, precisely because it's not concerned with that other aspect of the tort of defamation, which is vindication of one's reputation in that underlying sense.
Well, Mr. Justice Nicklin identifies, and by reference to Lord Bingham, two categories: vindication and, I think it's damage to reputation, and vindication of reputation,
yeah.
And says that neither of those can be awarded, but the third subcategory, which is distress and anxiety, may, but we add the important caveat to that may, if it crosses the...
Certainly, I understand your submission, but what I'm seeking to explore, while we're all here, is whether, in fact, there can be relief in relation to the tort of misuse of private information for damage to reputation, but it won't be the same relief as one would get in relation to damage to reputation under the tort of defamation, because the tort of defamation is serving this additional vindicatory function, and the damages are awarded partly because of that vindicatory function, which is not part of the tort of misuse of private information.
Well, my Lord, as long as my Lord knows that my primary submission is it's inappropriate to use this tort, and the reasons why it's inappropriate to award damages for injury to reputation in this tort argue in favour of this tort not providing a remedy for publication of information about a criminal investigation. That is the province of defamation. That will then inform the rule on interim relief. It will inform the rule on limitation. It will inform the available defences. But if my lords are against me on that, then I would certainly submit strongly that it should be no part of the emerging tort of misuse of private information to compensate for the vindicatory aspect, and that SICRI was rightly decided on that.
Yes, thank you.
Lord, can I then, and I'm sorry, it took a little time, but it's a very important aspect of this case.
Yes, I've allowed you to carry on longer than I might otherwise have done, because it is the court obviously regards this, at the moment at any rate, as an important aspect of the appeal.
Thank you. I was booked for half an hour, and I think I've already exceeded that, but I'll try and go more quickly on the remaining. My Lord, going back to the beginning of Mr. Owen's submissions yesterday, it quickly became clear, and indeed it had become clear during exchanges with me during argument, that some at least of my lords thought that it might be sufficient to establish the engagement of Article 8 if the information published impinges on private life. It doesn't have to relate to private aspects of life. That's again a formulation my Lord Reid put to Mr. Owen as the way he might put his case. My Lord, can I address that? Because that's a very important theme raised by this case and discussed in argument with both of us. And I submit it is incorrect as an analysis. It's important to remember that the context of this case is publication of information by the media. The media publish many stories that cause pain, distress, anxiety, outrage, loss of sleep, all the things that this claimant complains of. Such an impact or effect on someone of the publication of information doesn't make the information published that individual's private information. Otherwise, people offended by all manner of news reporting will say, this has caused me pain and distress, and you must take it down or not publish it in the future, because my Article 8 rights are engaged. And Lord, that cannot be right. Can I take a strong example on the facts from the case law? I've mentioned the case a couple of times, O against Rhodes, but my lords may not be familiar with the facts. This is a decision of this court in, I think, 2016. It's at page 3024. And you'll see why the facts are so illuminating. This is a case where the claimant was an 11-year-old boy who was psychologically vulnerable. He lived with his mother, and his father lived separately. His father proposed to write an autobiographical account of his, the father's, sexual abuse at the hands of teachers and others in his youth. The mother wanted to stop the boy from reading that because, and this was established on the evidence, it would not only interfere with his family life, it would put him at risk of psychiatric harm. There was expert psychiatric evidence that he would, if he read the book, be harmed by his father's accounts of his own sexual abuse. He's sued in misuse of private information as well as the Wilkinson and Downton tort. But the first instance judge, Mr. Justice Bean, and the Court of Appeal dismissed, struck out his misuse of private information claim on the basis that although the book, if published, would have a grave impact on him, up to and including psychiatric harm, the book did not contain the boy's private information. And therefore, the misuse of private information tort could not be used. The case then goes on appeal only in relation to the Wilkinson and Downton tort, where, as I've explained to you, the court draws the modern boundaries of that tort in such a way as to avoid overlap or inconsistency with the law of defamation. But, my Lord, it's a strong case on the facts of impact or effect not being sufficient to make information which is not the claimant's private information, private information. And my Lord, we submit that this case is about, whilst it is clearly and importantly informed by the Strasbourg jurisprudence, this is a case about the parameters of the domestic tort of misuse of private information. And the courts in this country have developed a tort not of impinging on private life, but of misusing another's private information. And so we submit as strongly as we can that a test of effect or impact divorced from whether the information in question is the claimant's private information will not do. Lord, I then want to address a number of other points briefly, if I may. I've dealt with the two main points I wanted to make in reply. The next point is this. Mr. Owen relied heavily on a number of occasions on the case of Cat. We would respectfully adopt my Lord Sale's observation that Cat falls into a recognised category of cases about the state compiling and retaining databases in relation to its citizens. And there's a helpful observation in our submission from Lord Sumption about that line of cases in Gallagher, which was the most recent of the cases in this court about the spent convictions regime. I think my Lord Reed may have been in it, certainly in T, I think.
Yes.
Gallagher is at the relevant paragraphs, page 3724. My Lords will recall broadly the series. There was re-L on cautions, with an observation in Lord Hope's speech about spent convictions. Re-T, then, which was a case on the spent conviction regime, followed by Gallagher, which was a further case on the revised spent convictions regime and its compliance with the requirement of legality. But the point I wanted to draw attention to at 3724 is in paragraph 14 of Lord Sumption's judgment in Gallagher. Gallagher's sometimes called P, I think. And do you see just between D and E, Lord Sumption says, it's fair to say that the jurisprudence of the Strasbourg Court has been especially sensitive to the keeping of files on individuals by the state, a practice which was gravely abused by the authoritarian regimes of the 20th century in most of continental Europe. This sensitivity explains why the right of privacy has been extended from covert and intrusive surveillance to the recording of things which would not be regarded as private in any other context, for example, participation in demonstrations in public places, and even public acts of the state itself, such as criminal convictions in an open court of law. So in our submission, that's a helpful indication of the width of the protection of Article 8 given by the Strasbourg case law in that particular subset of cases, of which Cat is an example. but my Lord, it doesn't in our submission assist greatly with the problems which confront the court on the present case. Then I next wanted to take up an observation my Lord Stevens made at the end of the day yesterday, which was about whether the Denisov consequences-based approach finds appropriate reflection in Murray, in the Murray factors. My Lord, our answer to that is that it is catered for by Murray factor number 6, the effect on the claimant. It is one factor, but one of several, and not enough of itself, for the reasons I gave a moment ago, to render information someone's private information. That is an important but not sufficient factor. My Lords, then moving forward to this morning, Mr. Owen taxed me on my objection to the general rule about information about criminal investigations by saying, well, we all know that medical information is a recognized category where there's a starting point. But, my Lord, in my submission, that suggestion proves too much. Medical records are a clearly recognized type of private personal information. They are always of that type. Whereas criminal activity, the facts involved in criminal offending, are not always of a private or personal kind, and this case is an example where the facts of the criminal activity are not within the sphere of private life. So that suggestion doesn't undermine my objections to the general rule articulated by the Court of Appeal in the present case. My Lord, a little later in this morning's argument, Mr. Owen added a point he said had occurred to my learned friends since they wrote their case, which was that the information about the criminal investigation couldn't have been obtained by Bloomberg or any other media organization pursuant to a FOIA request. And my Lord, it's a tangential point, but I ought to answer it. FOIA, as my Lords I'm sure know, contains both absolute and conditional exemptions to the obligation to provide official information. Section 30 of FOIA, which my learned friend drew attention to, is not an absolute exemption. It is a qualified exemption, which involves a public interest balancing exercise in the decision whether or not to disclose the requested information. So in our submission, it is of limited assistance in drawing the right or approaching the right answer in the present case. Shortly after that, my Lord Lloyd Jones asked Mr. Owen about the distinction between standing and reputation. My Lord, in our submission, the best guide is paragraph 23 of Caraco. Whether you call something reputation or standing or esteem, if what you're talking about is the external evaluation of oneself by others, that is outside Article 8. The label isn't important. The distinction between the external evaluation and the internal impact is what is important. Mr. Owen then moved on shortly after that to discuss what he called the emerging consensus from the Leveson inquiry onwards in relation to police practice. But, my Lord, two observations on that, if I may. Firstly, it is a consensus in relation to police practice. Police as forces, as public authorities, have no Article 10 rights, and the position in which they process and deal with information is different from that of the media. But I add the point I made a little earlier, which is that the basis for those police practice statements is said to be the risk of unfair damage to reputation. and we give the reference to that in our case. Once one sees that it is concerned with unfair impact on reputation, you're back at the point I began with this afternoon about the way in which, in the present case, and no doubt many others, publication of information about a police investigation bearing the defamatory sting of reasonable grounds to suspect would be defensible as true because of the conduct of the claimant who has brought the suspicion down on himself. Mr. Owen moved from that point to pray and aid opinion polls in Professor Phillipson's article. My Lord, it would be, in my submission, a somewhat dangerous step for this court to take to attach significance to those. Regrettably, the public are prone to support a number of things in opinion polls which this court would not consider a beneficial development in the law. My Lord, next point I wanted to touch on is this. Mr. Owen relied on the BBC case, read the BBC in 2009. Do you remember the case about the autrefois acquit rule being changed by statute and the BBC wishing to make a programme using the individual's story to illustrate it? But my Lord, at paragraph 22, on which Mr. Owen founds, one sees that Lord Hope reasons from the retention of DNA samples being an interference with Article 8 rights to the publication of information about the retained DNA sample being an interference with Article 8 rights. Well, that's a very different case. It's obvious why the retention of DNA samples engages Article 8. The state take them under compulsion from citizens. In addition, my Lord, the offence in that case was a sexual offence. So the particular problem about the nature of activities which is present in this case didn't arise.
Can you give me the page number, could you?
I'm so sorry, my Lord. Page 2257.
Thank you very much indeed. Thank you.
2557. I do apologise.
Thank you very much.
My Lord, Mr. Owen's next point was, again, drawing on Professor Phillipson and Mr. Craig, that data protection law classifies the alleged commission of an offence as sensitive personal data. My Lord, that is true, and it may be where Lord Justice Simon gets his reference to sensitive data in the third paragraph of the ratio of the case. But there are two very important points to make about that. One which emerged very clearly in the recent decision of this court in Lloyd and Google, where judgment was handed down last month. The data protection regime is not coterminous with Article 8 rights. Personal data does not have to be private. The data protection regime protects many kinds of data which don't fall within the scope of Article 8. And there is, and my Lord Stevens will remember this, there's a decision of the Court of Appeal in Northern Ireland called CG and Facebook, where the Court of Appeal say that there are dangers in treating the categories of sensitive personal data under the data protection legislation as if they were ex hypothesi categories of private information. My Lord, it may be a useful test at times, but it's not right to say that there has to be uniformity between the categories of personal data which aren't necessarily protected by Article 8 and the boundaries of the Article 8 right. Now, can I then address a small point?
Just on that, I mean, I think it can be said that the Data Protection Act, which implements the Data Protection Directive, is strongly inspired by Article 8 rights. I mean, the directive has recitals which refer to Article 8.
That's undoubtedly true, my Lord, but it was part of Lord Legate's judgment in Lloyd and Google that one difference between the data protection regime, one difference between the data protection regime and the developing tort of misuse of private information was that not all personal data falls within the scope of Article 8. But my Lord is right that privacy is an inspiration for data protection, but it doesn't mean that all the categories are within the protection of Article 8.
I think the Court of Appeal in CG took a somewhat different approach than I did. And,
but that's my Lord, that's right.
Of agony.
My Lord, Lord Reid observed shortly afterwards that Professor Moreham was a New Zealand academic. My Lord, I think for her sake to say that she held teaching positions in English universities before.
Yes. Oh, yes.
But and also more importantly, she's writing about the development of English law. She's the editor of the leading textbook, The Law of Privacy in the Media, which is not about New Zealand law, it's about English law. And that's a tiny point, but I just, since we pray in aid, Professor Moreham's analysis, I thought I ought to make it. My Lord, Mr. Owen then, looking at CUJA, pointed out, as I had drawn attention to yesterday, that at the end of paragraph 8, Lord Sumption refers to there being a real risk in this case of people not understanding the presumption of innocence and thinking the worse of Mr. CUJA if the matter was published. And he said, and I hope I've written this down accurately, that the facts in many cases may mean there's a real risk. But, my Lord, many cases won't do for a general rule of the sort that the Court of Appeal has articulated. The next point I wanted to touch on is this. Mr. Owen, I dealt with this preemptively yesterday, but I'll come back to it. Mr. Owen suggested that the defamation law concept of an ordinary reasonable reader is part of a single meaning rule, and that's been jettisoned even in other speech torts such as malicious falsehood, and he referred in that regard to the case of Adjunimoto. But, my Lord, even in malicious falsehood post Adjunimoto, the court still looks only at reasonable meanings. It doesn't look at unreasonable meanings, and it's hard to imagine any branch of the law, and certainly this shouldn't be the exception, proceeding on a posited or hypothetical unreasonable reader. And so we submit that point doesn't take him very far. My Lord, Mr. Owen then mentioned Cushionan, my Lord Stephen's judgment in Cushionan and the BBC. We fasten on to the reference to the absence of an occasion of privacy in the judgment, and we submit that that need for an occasion of privacy is consistent with our analysis of the scope of the tort, and it isn't. That requirement isn't met by Mr. Owen's suggestion that the occasion of privacy here is the scrutiny by the UKLEB. The occasion of privacy was, or has to be, the underlying factual conduct under investigation, which wasn't, in the present case, on an occasion of privacy. Lords, I've said enough about outflanking of defamation and about SICRI, and I think enough about the practical problems. It did strike those who instruct me when we discussed on-account damages over lunch that there might be difficulty in recovering sums paid on account from people who might be likely to sue in situations like this. My Lord,
I thought the suggestion, I'm not sure I fully followed it, was some sort of payment into court on an escrow basis. Yeah. You'd get it back from the court.
That was one of the points mooted, and my Lord, I was just teasing slightly at the suggestion that one might make a payment on account in case. If one made a payment into court, it's cumbersome, and I fall back on my question that Mr. Justice Warby asked and answered, we say compellingly in SICRI. Why introduce all the difficulty which it would introduce when there is the mature and natural tort available? My Lord, unless I can help further, those are my submissions.
Well, thank you very much, Mr. White. This is obviously a case of importance in the development of this tort. We're grateful to all involved for their assistance. We'll, I think, take some time now to consider our judgment in the case, and we'll let you have it in due course.
Thank you.